We usually involve your family lawyer from your home country or Canada, and we show that that spouse has been contacted and that they're unwilling to provide this information. And then it gets a little bit tricky with the immigration officer. Often what happens is that the application is put on hold until a final divorce certificate is provided, and then that way they can be removed from the application. Which brings me to my next point. So if you're filing for any economic class of immigration and you are divorced, it's simply like a marriage certificate. You just provide a divorce certificate for that divorce, and your ex-spouse is not considered as being part of the application. I also wanted to mention how children and custody issues can be affected. Obviously, when talking about divorce and separation, there are often children who are involved. It's important to note that if you're separated or divorced from your spouse, but you're including the children on the application, they also need to be examined and included in the application. So remember, this is stepchildren and biological children as well. It's important to note that even if you don't have custody of these children, they need to be involved, and vice versa. If you have full custody, the other parent needs to agree to them immigrating. There's a declaration from Immigration Canada, an actual form that the parent of that child will need to sign off on and have notarized, saying that they agree that their child will immigrate to Canada and that they authorize them to do so. It's really important that you can get this information, because oftentimes, unlike a divorce or separation, without this document, the immigration officer won't approve the application because of international laws on children and movement of children. You can't remove your child from a jurisdiction where the other parent lives, even if you have full custody of that child. I also wanted to touch on divorce and separation during spousal sponsorship or common law sponsorship applications. So things differ a little bit. Divorce and separation are a much bigger issue if it occurs while the application is still being processed. If you separate from your spouse, then you're no longer considered to be living in a conjugal relationship with that spouse or common law partner, and as such, you are not actually eligible to continue with the sponsorship application. If it happens after the principal applicant, so that's the person being sponsored, is approved, then it doesn't actually affect your status. So they took away the rule that you had to continue to be married to your spouse for 3 years after you were sponsored. But what still comes into play is the issue of misrepresentation. So you do have to be careful that if you separate and divorce from your spouse who sponsored you and vice versa, after you gain permanent residency,